want to say welcome again to those of you joining us on Zoom, those of you on Facebook, on YouTube, on IKTV, and those of you who have joined us by radio. Now, it has been over a decade and a half that work has been going on relentlessly, tirelessly. It has been grueling, but it has happened, and we are now at perhaps one of the high points of all of the activity. As you would have seen from your invitations, we are going to be heard in the Caribbean Court of Justice on the 29th and 30th of April. And so before we go to court, we just want to bring you up to date on all that has happened over the last decade and a half. We have brought together a killer team to make sure that you have the best representation at the Caribbean Court of Justice. And in addition to our lawyers who are trained in different aspects of law, we also have experts who are skilled in economics, trade regulation and competition, civil fraud, and corporate law. So you're in good hands. And today you will hear from Dr. Patrick Antoine, the president of BACOL, and he's a renowned Caribbean intellectual and regional thinker with a wealth of experience in both public and private sector affairs. Dr. Antoine has been the lead consultant on myriad projects, including Caribbean Communities Regional Negotiating Machinery. He has been the lead consultant for CARICOM and for the Minister of Finance and the Cabinet of Grenada. He's a former ambassador to the World Trade Organization and a former ambassador extraordinaire and plenipotentiary of Grenada to the Caribbean community. He's a former trade and economic commissioner to the Republic of Trinidad and Tobago, a former commissioner to the Organization of the Eastern Caribbean States, and a special advisor of the Inter-American Institute for Cooperation on Agriculture. We are also going to hear from Ms. A.L. Menz. Ms. Menz is an international legal consultant and has been working as a legal academic, practitioner, and advisor since 2002. She's a US and EU trade regulation and competition lawyer versed in the language, substance, and procedural aspects of her areas of expertise. She also advises several governments and government agencies on competition, trade-related policies, and economic affairs, including governments and government representatives from the Bahamas, Barbados, Jamaica, Turks and Caicos Islands, the Gambia, and Sierra Leone. Ms. Menz also works as a trade-related economic affairs advisor and competition law consultant to the United Nations Conference on Trade and Development. More recently, she has designed the strategic and methodological approach for the Turks and Caicos Legislative Review and Drafting Program. Once again, may I ask you please mute your microphones, as we would not like to have any interruptions during the presentations. We will ask our speakers to present first, and then we will take your questions. You can post your questions here using the chat function on Zoom, or if you're viewing on Facebook and YouTube, you can post your questions there. So once again, please hold your questions until after both speakers have presented, and then we'll take your questions here on Zoom, on Facebook, and on YouTube. Our first speaker is president of the British American and Colonial Life Insurance Companies Groups, Dr. Patrick Antoine. Dr. Antoine?
Colleagues, so good morning to all of you, those of you who are policyholders, fellow policyholders, and to members of the press and other interested persons from our Caribbean civilization and beyond. As you would know, this matter of the British American policyholders' inability to get full compensation for the investments made in BACOL, British American Investment Company Limited, and the sister company, CLICO, the Colonial Life Insurance Company, has been ongoing since the meltdown, the collapse of the CLF empire and the subsidiary companies in 2009. It has been a long journey, and recognizing the inability of our regional governments in the OECS to successfully, let me say, benefit from some understandings made at the level of heads regarding the compensation to policyholders in the Eastern Caribbean. My words are very carefully chosen because, in fact, there was a negotiation and there was an indication of an initial settlement amount. We've had to step away from that and to pursue our rights under the revised Treaty of Chaguaramas as CARICOM nationals. So I wanted to make that point early, because what we're doing as CARICOM nationals is exercising our rights under the revised Treaty of Chaguaramas. It has nothing to do with what governments have done. It's a process that quite cleverly in CARICOM, the framers of the revised treaty and also in the way that the court has operated has now provided the private citizens with the ability to approach the court where they feel that their rights in treaty have been infringed. And so as policyholders, having had discussions in Grenada in 2013, a company was incorporated in 2014. Stacey is telling me 2015. You would forgive me if my memory fails me sometimes on this one. It's been a long time. So the company was incorporated in 2015, October, and we formed a common cause with others across the Eastern Caribbean who shared in our predicament. And very quickly, we were able to join forces with the colleagues in Antigua and Barbuda, and subsequently with our colleagues in St. Vincent and the Grenadines, Dominica, St. Kitts and Nevis, Montserrat, and some colleagues from St. Lucia who have been able to get their own policies covered under some other arrangements that we have. So what we represent today is BACOL, the British American CLECO Policyholders Group. It is a group of private citizens. We have come together as the first group across the Eastern Caribbean, in fact, the first grouping to appear before the court as opposed to individuals. And I think you all need to be very proud, the policyholders and those who have enabled us, the attorneys in the countries, the country managers who have facilitated us, our PR firm, Hiruna Media, and all those well-wishers who have come together to help us to be able to essentially launch a very successful organization, which has led to what we are going to be talking about today, which is a matter that finally will be heard by the Caribbean Court of Justice. It's been a road which has taken us from 2015 to 2024. And we were able to make our way to the court in 2021. And so as these international matters go, one would say that from 2021 to 2024, it's been a pretty short period. It's an international claim that we're bringing under the revised treaty in the original jurisdiction. So BACOL represents nearly 2,000 policyholders. Our policyholders in the Eastern Caribbean are owed about 800 million Eastern Caribbean dollars that have not been fully compensated by what we claim ought to be a process that covered Trinidad and Tobago policyholders. So we've argued that it is discriminatory. We're not going to get into the specifics of this today, and there's an element of this I'm going to ask Ms. Menz, who is with us as a colleague and as someone who has collaborated with us on this matter, to get into an explanation of what the basis of it is and why it is so important for us to take this matter to the CCJ for, as it were, some determination, because it does have far-reaching consequences. But where we're concerned as BACOL, and certainly as the president, representing nearly 2,000 policyholders, and approximately $600 million. So of all the funds in the Eastern Caribbean, we represent, a significant amount. 600 million of the $800 million would be represented by us. And of course, unfortunately, I make the point deliberately that of the policyholders that we do not represent, many of them have unfortunately passed away. We've lost quite a few members since we've started. And even before we started, the human and social cost of this debacle has really been significant. And it's been sort of very, very painful for us in the executive to look and to hear of all of the stories of persons who ought to have, in their latter years, been in a better position to look after themselves, were it not for the fact that their resources were not available for their use for medical purposes, for looking after their just day-to-day expenses as they've aged. Many pensioners who have been reverted to a status of poverty as a consequence of this. Many parents who have been, unfortunately, not able to look after their children, and many have had to withdraw their children from university programs, from vocational institutions abroad. The social cost of this on the OECS has been high. In fact, I dare say there's been no single matter, and I think the World Bank bears this out, that has been so impacting on the growth and development path of the OECS countries, save and except natural disasters, as this has been, and many families have still not recovered. So today we are very delighted that we're going to court on the 29th and 30th. And we're going to court based on a ruling from the court that in the first swatch, since we made the decision tactically to run with the policyholders from Grenada and Antigua and Barbuda, while the other islands were being settled, we made the decision to approach the court, fearing that we would be out of time. The court, after giving an indication that we should submit all the names, made the ruling that we should proceed on the basis of the policyholders from Grenada and Antigua and Barbuda, who were initially signaled to the court as a strategic move by the team to ensure that we got the case in before we'd lost any more time. Those policyholders that have not been essentially parties at this stage to the claim must not feel that they are left out, because the court has made it clear that once the court has heard the arguments, which are the same for the other islands, as they would have heard based on the claimants from Grenada and Antigua and Barbuda, then of course, because it's the same case, it's the same arguments, the other policyholders would be accommodated. So we could do that in several ways, which the legal team is well aware of and well seized of. So those of you who are on the call, who are from Dominica, who are from St. Vincent and the Grenadines, who are from Montserrat, you must have no fear that this matter that has reached this stage, based on your own participation, that this matter also continues to include you. I want to leave that with you today, so that what is going to happen on the 29th and 30th, the outcome of that will determine in large measure, though not in whole, what will happen to your claims with us as members of BACOL. So you can rest assured of that. I want to, in going through all of this and in allaying all the fears that exist, to say that on the first day, because I know many of you are on the call to hear that, we are going to be getting submissions from the witnesses, and there's going to be cross-examination, etc. We are sure, because the court hasn't given us specific instructions on this, but it is unlikely that on the first day, when the witness statements are being heard, that we will have a public link. But on the second day, we are verily sure that we will have a public link, and as soon as we get that link, we will send it to you. So we anticipate that we will have that link by Friday. We will send that public link to you so that on the second day for sure, when the court is open to essentially having viewership and participation from the broader community, you will be given that. Now, let me be clear. If there is an opportunity for a link that is public on the first day, we will provide it. But at this stage, we are unsure, but rather err on the side of caution in suggesting that perhaps the court may not want that on the first day. If there is need for a third day, the court has also made some allocations for a third day. If the matters go over, that's going to be on the 1st of May, which is not a public holiday in Trinidad and Tobago, okay? So as far as we are concerned, we have done everything that we can do. We've brought an extremely competent team together. Over the years, the team has been strengthened. We have a team that's led by Simon Davenport, who is a KC out of the UK. He's been with us now for about 5 years. We have had Dr. Kenny Anthony, who's been with us for a longer period. And you well know Dr. Anthony's credentials. We have a firm from Trinidad and Tobago that's among, I would say, the 2 top firms in our community, but certainly a top firm in Trinidad and Tobago, Hamill Smith. And we are lucky to have Gregory Pantin and Miguel Vasquez. And they've been with us from the inception. I want to say now for about 9 years. We also have someone who was at the CARICOM Secretariat and is now in private practice, who is a Montserratian national, George Kernan, who is on our team as part of the community law expertise. We do have as well giving us some legal support. He's not an attorney, but he's been part of our research team on the legal side and has done really good hard yeoman service in helping us to do coordination, legal research, and strategizing. And this is Joseph Lane from Grenada. And I want to say that all of this benefited from all the attorneys across the OECS whose names are going to be reflected in a bulletin, no matter what the outcome of the case is. But clearly we expect that the court will rule in our favor having regard to the strength of the team. And let me say that the team more recently has benefited from someone who has just strong expertise in this area, KL Menz. And while she's not appearing before the court, she's really given us access to someone who is going to be called to the bar in St. Vincent today. His name is Carsten Zachler. And we want to thank the OECS legal fraternity for facilitating his entry to his being called to the bar in St. Vincent and the Grenadines, which is being called to the bar as a prerequisite for being able to appear in one of the CARICOM jurisdictions. And he's going to be appearing for us before the CCJ next week. So he's called to the bar today, and he's going to be appearing with us on Monday, Tuesday, and if necessary on Wednesday. We know that many of you are jittery, but you really have no good reason to be, because I think the story is yours, and all you're doing is really reflecting what has been a very painful story on behalf of us all, to our distinguished judges at the CCJ, a panel of judges at the CCJ. Now, more than likely, we're sure that all the judges are going to be seated. So the entire panel of judges will be before the community, essentially hearing this matter. I'm going to rest and I'm going to ask immediately for KL Menz to speak about the basis on which we are now proceeding on this case next week, having regard to the fact that part of the basis that we put forward, because as we told you before, we were going on several tenets. And one of the tenets was set aside, and I know many of you became anxious, but it's strategic for us to proceed in this way. And the remaining tenets of the case, I'm going to ask Ms. Menz to talk about the importance of that for you and the importance of that for the Caribbean community of citizens. So if she comes in, then we can then have a chat afterwards about any questions and concerns that you would have regarding the case. So we're at the threshold of making finally our matter heard before the court, because the previous matter was actually determined on what we'll say a points limine. There wasn't a hearing, so to speak, on it, and we're now having the hearing for the first time to get into the substance of this matter. So Cleo, I'm going to ask Ms. Menz to join us immediately, and then we can have questions.
Good morning, everyone. Good morning. Good morning. Thank you very much for having me. I have been introduced. I'm Kale Menz. I am a competition lawyer and a trade regulation lawyer, and the areas that we advise on include not just competition and regional integration treaties, but more recently, banking law, banking regulation, financial inclusivity, and of course, financial consumer protection. This case, the instant case, concerns a pure question of fairness, discrimination, and leveling the playing field for community. And when we say community, we're talking about Caribbean community consumers. The main issues are basically that in its compensation scheme, the government of Trinidad and Tobago effectively, factually, favored its nationals, the nationals of the Republic of Trinidad and Tobago. And by the deliberate use and expropriation of the CLF group of assets to benefit the Trinidadian policyholders only, and to compensate its policyholders only, and to form a new business entity which benefited its policyholders only, it discriminated against the Grenadian and Antiguan policyholders. Now, I won't go into any discussion or preempt what the judges are likely to decide, but I can tell you what the significance of this case is to the broader issue of consumer protection and the broader issue of the single market. And when we say the single market, we simply mean we are trying to create an amalgamation of our single market countries, which I think probably number maybe 14 or 15. And we want to add all the businesses, medium-sized, multinational, small businesses, and all the consumers across all of the CSME member states to create in excess of the 70,000, 60,000, 2.5 million, or 3 million citizens you will find in individual member states, so that you have a greater and bigger amalgam of businesses and consumers in excess of, let's say, 7 million when you add us all up. That presents for all of us a greater scope for improvement in standard living, wealth creation, and doing business. So, for example, what we want is to see Vincentian consumers being able to buy goods in Trinidad, have them shipped duty-free, so that all you pay for is the shipping cost and the cost of the goods. And the same thing for services too. Free trade, unencumbered by discriminatory subsidies, duties, or any other public or private restraint on trade. In the context of this case, three things are happening when the judges rule before the CCJ sometime in May. One, for the first time, we are now venturing into, and it's probably not the first time because there have been other business cases, but for the first time, the consumers can see the real benefit and the real impact of the RTC to them. Many people think of the CSME regional integration as something that is the sole responsibility or privilege or benefit that will inure to our member states. or big banking institutions or big Trinidad cement. That is not the case, and that's not what the revised treaty is intended. So the sole responsibility, the sole obligation, and the benefits do not inure to member states alone. And in fact, this case will show that consumers have as much rights, privileges, and obligations and responsibilities under the treaty as our member states. And even though it's the member states who come together and formed, became the signatories to the treaty and ratified the treaty and incorporated it into their national law, it is now time for our consumers to benefit from that treaty. And we don't need governments to tell us whether we can profit from the treaty or not. We don't need governments to tell us that we must wait for the treaty to be amended for us to actually start taking advantage of the CSME. And this is one of the critical things about this case and bringing this case before the CCJ. Now you see consumers can absolutely enforce their rights under the treaty. And that's one of the main things that you will see happening now. I think you will see a lot more cases after this one where consumers, small businesses are now being made aware of their rights to actually use the treaty unamended as it currently is. And the second thing about this case is creating an enabling business environment. For too long, we've been waiting for our various member states to give us the go-ahead to start trading, and that is absolutely not essential. We have an effective Caribbean Court of Justice court system that can be petitioned to ensure that when you start taking advantage and using the various provisions under the treaty to do business on a cross-border basis, you can effectively petition the court. There is this sense that we must wait for the governments, we must wait for the ministers, or we must wait for the governments to create a Caribbean or a CARICOM legislature. None of that is necessary simply because the treaty has been incorporated into law. And the normal lawmaking processes of the Caribbean tell us that if something is incorporated, enacted by our legislature, and it is gazetted, it is the law of the land. And the Caribbean Community Acts in various member states has been enacted, has been gazetted. And that alone makes the protocol on consumer protection and makes the various protocol on non-discrimination and leveling the playing field for businesses and consumers across the board. That alone makes the treaty effective and ready to use. That alone creates a strong enabling business environment. We cannot have a situation where we have made it easier for Caribbean citizens to buy from Temu or AliExpress or Amazon than it is for them to say, buy from a Trinidad or a Belize or a Jamaica. We cannot create enabling business environment more favorable to extra-regional countries than we do for our own CARICOM. And so this case will make it very, very plain that you go ahead as a consumer, petition the court. You go ahead as a small business, petition the court. No longer do you need to wait for member states to go ahead and pass various ancillary legislation in their member states to say the treaty is now ready. No, the treaty is ready now. And this case is a wonderful example demonstrating just how much we can petition the CCJ to have our rights that are observed by the treaty put into effect. And those are the main 2 points. The final thing I want to say is we are so loud about sovereignty in the Caribbean. And we like to use sovereignty and this national sentiment of our sovereignty and not having it abrogated as the reason why the treaty can't go ahead, as the reason why we are so limited in our use of the CSME. We have our member states having ratified this treaty since the 1990s and incorporated it into various legislation since, for example, 2001. When a member state or any state at all enters an international treaty, by the mere ratification of the treaty, they are subverting portions of their sovereignty to achieve the outcomes under the treaty. Here it is, we've all come together as CARICOM or CSME member states to ensure that we've signed various protocols under the treaty on consumer protection, on subsidies and countervailing duties, on anti-dumping, on competition. We've signed all of these various protocols. And these protocols mean that by agreeing to institute these things, by agreeing to harmonize our law, by agreeing to observe all of these various legal issues under the treaty, we've agreed to subvert our sovereignty. And in any case, the idea that extraterritorial application, giving access of Grenadians, Antiguans, and Vincentians to Trinidadian redress or Trinidadian compensation, if that to the mind abrogates Trinidad's sovereignty, then what would you say, you know, a Trinidadian government applying its criminal law to someone who committed a murder in Trinidad, who is from another member state? What would you say in those terms? Aren't criminal legislations, you know, given extraterritorial application? So if civil law, criminal law, etc., can be given extraterritorial application, why can't the various laws under the treaty be given extraterritorial application? It really, really doesn't actually make sense in the context, you know, of a sovereignty discussion. So the point is, the treaty is ready, it's there. You will find that even though we do not have all the cooperation systems in place as yet, there is nothing that's going to kickstart cooperation among, let's say, national regulators, one, you know, Fair Trading Commission in Trinidad versus, you know, the Consumer Protection Authority in Jamaica. Nothing is going to kickstart that as the citizens of the countries petitioning the court saying, I'm ready for my rights to be acknowledged. So all the various systems of the treaty itself, all the various cooperation it requires, all the various ancillary legislation it requires passing, none of that will take place until people start actively using it, actively implementing and pushing for their rights to be acknowledged. And this is one of the things that this case will do. It's a very, very important case, which is actually pushing the governments to start creating the necessary institutional frameworks, the necessary harmonization, the necessary cooperation between national regulators, the necessary cooperation between the national courts, among the national courts, to get the single market up and running and recognize the rights and privileges of small businesses, consumers, multinational businesses, etc.
Thank you very much, Ms. Menz. Ladies and gentlemen, we've heard from our presenters. We can take your questions at this point. We already have a question from, I'm not sure if it's Jose or Jose Laurent, asking if there's going to be a press release as to the persons who are representing policyholders across the region, and whether or not policyholders will be able to see the proceedings on the 29th and the 30th. And one of the persons on the chat answered half of the question. Thank you very much. But in terms of the persons representing the policyholders of BACOL, in terms of the persons representing the policyholders, we initially had a list of all of the persons representing policyholders in the media kit, which was posted on the BACOL website. We will have to update that because, as you heard from Dr. Antoine earlier, some of the personnel have changed, and so we will provide an update shortly. For further information, you can also check the BACOL website, www.bacol.info, www.bacolbacol.info. And in terms of the link being available, As Dr. Antoine said, the link on the 29th is not yet available, but for those of you who have already received the stakeholders update, you would have the link attached in your message for the 30th. If a link becomes available for the 29th, we will also issue that link to you. And as to whether or not the recording will be available, yes, the recording will be posted to the BACOL website as soon as it is ready. Dr. Antoine, we have a question. How will the outcome of next week's proceedings affect CLICO policyholders?
Yeah, thank you very much for that question. In fact, I made a note here that I would then get into this specifically in the same way that we are prefacing and promoting this case to the court on the legal tenets that we have. Once the court determines on those matters, it's going to have immediate and identical application to the CLICO case, because it's the same matters that we're talking about and the same basis or cause of action that we're going after on the CLICO matters for CLICO policyholders. There was no point in us trying to launch two cases at the same time. Why? Because the premise is the same and the evidentiary basis of just supporting this one case has just been enormous. I think the witnesses will tell you all the hoops we've had to go through just in terms of being able to get all the evidentiary and supporting material, not to mention the material that does not directly relate to the witnesses. And of course, it's been just an enormous body of law that we've had to go through. And we want to thank KL Menz and her team for helping us with this too. All of those matters in the same way, once we're successful here, will allow us to transfer that learning, that knowledge, the same legal arguments, the same premise on which we've gone on to the CLICO case. So that's the decision we made there. And the other factual basis that we've made that strategic decision on too is that we had far more of what was required to launch this matter on the British American basis than on the CLICO basis. Everything that we advance as part of the reasons for the cause of action, we have to support, right? And that meant that we didn't want to delay the cases anymore. We had far more on the BACO than we had on the CLICO. And so we decided again, just as we did, where we had to make a decision on whether we waited until everybody was ready in the Eastern Caribbean or we would go ahead, and we made the decision to go ahead. We had to make that same decision as well. And so no prejudice is brought to CLICO policyholders, but all eyes should be on this case because it's the same basis that we're going to be going on, the same grounds. And I think the court is now well seized of the fact that there are other policyholders that face the exact same circumstances. So once this is determined, it will have application to them as well. Thank you.
Kathy, I hope that answers your question. Dr. Antoine Lucille says she may have missed the information, but why is it that all of the islands are not included? Why is it just Grenada and Antigua? Yes,
she did miss it. We had to make a decision on not losing more time as we settled all of the arrangements for the other countries. This would be St. Vincent and the Grenadines, Antigua and Barbuda joined the BACOL perhaps a year or so earlier than the other countries, just in terms of getting the arrangements settled. And I want to thank Haroon and all the country managers for working with us, because there was a strong possibility that without their support, this would not have been done. But I can tell you this, it would not have been done in the time frame. And so because Antigua and Barbuda, they were ready because they joined BACOL early, and we didn't want to lose any more time. We had gone ahead and strategically submitted the names we had for both Grenada and Antigua and Barbuda prior. so that Trinidad and Tobago, that on their side, they indicated the need to literally go through these names and literally having our support with policies, actual policies. And without losing another year or so while everyone was ready, we made the decision that we needed to get this matter before the court. And of course, we then tried to get the other policyholders to come on, which is a provision that exists in the court, in the rules of the court. And all it means is that you take the case the way you find it. But even then, because of the enormous work that would have to be done, as Trinidad and Tobago argued, we didn't argue this. We argued the contrary, that they would have to go through every single policy. The court felt it optimal to go with the Grenada and Vincent and Antiguan policyholders first, and then to bring the others sort of into the judgment, depending on what the court determined, based on the legal tenets that we've gone forward with, because these are persons that face the exact same circumstances as the policyholders in Grenada and Antigua and Barbuda. So there's no prejudice brought because they are not named as claimants in the case. Trinidad and Tobago is aware because we did make that submission before the court when they asked us to submit. So the court has a record of all of the names of persons from all the countries. And so once there is a ruling, Trinidad themselves have conceded that the ruling will apply equally across the board. So that's the reason I gave earlier, and I've just given you some more information on how the policyholders are going to be treated. There is a technicality, which I'm not going to get into now, but clearly, because the other policyholders would not have been they would not have had their day in court, it does allow for certain other possibilities later. So, you know, we're looking at that, and we have a good team strategically that's working through all of these issues. But we think that there is no prejudice brought at all from not having all the policyholders at this stage in front of the distinguished judges of the court as they hear the pleas that we will make on Article 184(1)(j).
Thank you, Dr. Antoine. Those of you listening via YouTube and via Facebook, please feel free to post your questions there. Lucille, I hope your question about whether or not we will all benefit at the end of the proceedings has been answered. We have a follow-up question, Dr. Antoine, and it is from Kathy. She's wondering if you have a timeline as to when a decision will be made by the court, and from then as to what time a financial resolution can be expected for the policyholders. And DJ is asking, if there is a judgment against Trinidad and Tobago, will there be a right of appeal?
So there is no right of appeal because this is in fact an international court and it's the final court. The CCJ has operates in two jurisdictions. One is in the original jurisdiction as a trade court, and of course, you know, it's a final court for many countries as well that replaces the Privy Council. We are in the original jurisdiction and there is no appeal. It really is a matter that we are going to put, as we have, the best case forward, leave it to the judges. And clearly, those of us who believe in the power of prayer as well, that's answering that question. The first question in relation to the expected time. We expect this matter is going to be ruled on by, we anticipate the third quarter. So optimistically, we think certainly before the court goes to recess, but we're not optimistic. We think it may be when the court comes back, and that's in the third quarter. So we're talking about sort of September, October. That's what we expect as an outlier for a judgment. And of course, this is the first time the court would have had to address issues that we've raised. on consumer protection. And so knowing that it will form precedents for the way in which matters going forward will be determined on this premise, we know that they're going to want to be cautious, which is why we've brought our best game on the law side to bear on this matter. So that's what we expect in terms of the time frames. The issue of compensation, we are going to be, and we have requested that we be treated equally. What's that going to look like specifically? There's several variants. One variant is that if we've gotten 13 cents on the dollar, that we get the other 87 cents plus interest. Another variant is that we get the 87 cents, you know, plus interest, and the interest could vary, whether it's going to be the sort of interest that's applied, you know, in the domestic courts that we have, is a matter that the court will have to decide. So there are all sorts of variants in terms of what the compensation could look like, whether it is full compensation having regard to the passage of time, because the time value of money becomes important. People who got compensation in 2010 and 11 would have had the opportunity to benefit from that, while persons who were not compensated would not have had that benefit. So those matters are going to be taken duly into account to ensure when that time comes. As you know, I'm an economist, so we would obviously run our models as we always do, and we would have every single variant, as we definitely will. So you're going to be in the best position to be represented both from the financial, economic side and also from the legal side. So we're asking clearly for interest, and we're asking that we be made whole, and we're asking that some element of cost also be covered, because we have incurred an enormous amount of cost with this project, some of which our policyholders have offset, but that's been really a drop in the bucket. It's been, think about it, it's been lawyers since 2015. And, you know, we couldn't have gotten to this stage without the assistance of some colleagues who before that gave up their time without charge, and I do mean substantial time. So, you know, leave it to us, but we've given you a sort of ballpark in terms of the scenarios that we're going to be looking at once we come to the issue of compensation. All right, but you're in good hands.
Dr. Antoine, are you able to give a sense of the main risks that you see going forward for the policyholders in terms of the progress of the case and the outcomes?
Look, when you go to court, you know, you're placing your faith, and in some sense your destiny, in the hands of men and women who are mortals, right? They are mortals. They are just men and women. And as with any other case, we can only control the factors that we can, which is we've really labored at bringing what has been I would say, the most complex case that we've had in the community, involving 6 different jurisdictions together. And it's the first, if you were to talk about class action suits, it's the first group claim that we've ever had before the court. It's been complex, but we've had to organize to ensure that we gave you the best representation, because we are dealing with men and women who are mortals. Mortals sometimes ill. Many times, more times than not, we say mortals get it right. So the main risk is that the court of mortals don't view the case in the way that we do. To mitigate against that, we have brought the best team, we've brought the best information, we've brought the best strategy, and you know, we've brought the people together who have been most affected. In short, we approach the court knowing that our cause is just. And when we line up all of those factors, I have to believe that, that the outcome is going to be favorable. But let us be real this morning. We are dealing with mortals, right? 5 or 7 men and women, and we are putting our information forward, knowing that it's the best information possible. It's the way that we view the matter. In fact, we've come with case law from other places as well. And ultimately, they will make a determination. I will tell you this, to my mind, again, speaking very openly as a CARICOM national, if this matter isn't determined, I think, in accordance with how we deal with consumers across the community, it is certainly going to impact the way in which I think we have a successful CARICOM CSME. As a civilization where we're trying to do cross-border trade, and we're trying to accelerate the pace at which we've moved, where small businesses can buy instruments, whether it's from commercial institutions, insurance companies and entities, and be treated in the same way, whether they are nationals of the country where the entity is actually centered or not. It's going to impact the pace at which the CSME moves. And I think that fact can't be lost on the court as well, but we have to leave it to the court to decide. So I've given you a fulsome, frank, honest view of the way that we look at this. I am a policyholder as well. I feel the same way that you felt in terms of, yes, we have some moments of trepidation, which is why I think we put our all into this. Every single one of us here, in one way or another, have been impacted. So yes, there's some risks, but I think they're minimal compared to the great optimism that we feel about the case. Thank you.
We have said that it is close to $800 million that is outstanding to policyholders. BACOL, in terms of persons registered with the group, is responsible for close to $600 million of those dollars. And I think someone is asking very specifically, in terms of the amount that is owed to the registered policyholders, what can we reasonably expect to receive as settlement?
Thought we answered that. What we said is that if we got 13 cents, right, then it means that whatever your policy amount is, right, you would then get the rest, which is the 87 cents. And we said, okay, that's the bottom line, right? And we said, now, if we put interest on that, then depending on what is determined, you will get the 87 cents plus interest over time. And we said there was another scenario where, because of the time that has passed, one way of looking at this is to say, look, all of this can be rolled up with a settlement of just giving us our principal back. That's another option. Clearly, if you put interest compounded on 87 cents, you'll end up with more than $1. So that's on the upside. On the downside, if you take no interest into account, but we just get what's remaining, that's the 87 cents. So the bottom line is 87 as far as we see it. And on the upside, it is going to be more than the principal that you put in because of the time value of money. So the straight line computation would just have us take $600 million multiplied by 87 cents. And that will tell you as a group what we expect to get. And on the upside, you can take $600 million and say, look, if I put 10% on that, then that's what it's going to look like. So I've given you sort of the bottom line and the way that we look at this on the upside. That's going to give you a sense of what the dollar amounts are. But look, I want to make this point. Clearly, we want our money back. When we met, that's the mantra that we spoke to at every meeting. We've prayed for it as well. And I'm not going to apologize for those who, you are free to pray in your own way before your own God, but I pray. I'm a proud, strong fervent Christian. I used to be quiet about it, but I'm not quiet anymore. I'm getting closer and closer to making my maker, so I've become wise. But I have to say this to you, that having regard to everything I've said, there is a way in which I look at these things, and I know all of the executives and the lawyers we've spoken to look at it this way as well, which is why I preface it this way. There is something called a just cause. And I believe that in addition to the money, this is something that had to be. We could not, as an OECS civilization, as CARICOM nationals, sit where we felt that our rights were trampled on and decided that anything up. So I wanted to just make that point, because in all of this, sometimes we lose sight of the fact that at some stage our civilization will have to record that we stood on this term, that we approached the court, that we were able to form common cause across all of the OECS as private citizens, not as governments, that we were able to get lawyers to make contributions in every country of their time and their dedication and their staff, that we were able to get colleagues from Trinidad and Tobago who we're taking to court, colleagues from Jamaica, colleagues from Guyana. We were able, all of us, to work to say to our Caribbean civilization that we believe that the integration effort is about more than just money. It's about us trying as a civilization to treat each other fairly, and with us being able to make sacrifices for each other in pursuit of this notion of fair treatment, all of the sacrifices that have come from the professionals. So for me, this is already a success. This effort that we are engaged in, where we came together around this common purpose of ensuring that justice is properly served, is already a success. And I just hope that on top of that, the icing for me is going to be if we are successful and you're able to get your monies back. And I know that for some persons it's inverted. You know, the success for you is going to be the money. And I can't tell you that I fault you. But I think we must all appreciate the fact that there are different dimensions of success. And this is certainly one, which is why today, as we stand here and we engage with each other at the threshold of approaching finally the court on this matter, that we've already achieved one of those significant markers of success, which is the solidarity that we've been able to create amongst ourselves.
Thank you, Dr. Antoine. And we have some support coming from Jeffrey Douglas Murdoch. He says, I support Dr. Antoine's comments and reference to the fact that policyholders have contributed when providing their claims. And you also said that contributions are really a financial drop in the bucket. The effort is very expensive, and hats off to the personnel collating time, energy, resources, those who helped to put the thing together, the selfless efforts of the main players to move forward despite limited contributor resources and finances. And based on personal knowledge, I know that policyholders have been asked to contribute very little relative to the cost of work that has to be done to obtain some sort of financial justice. So I just want to add to Mr. Murdoch's statements and congratulate the BACOL movement. We have members of the media who are on this Zoom meeting. Please, if you have your questions, you can post them in the chat. Dr. Antoine, are you able to say where the money is coming from to repay the policyholders? And is it actually already set aside?
No, we are not able to say where the funds are coming from. The matter is against the state of Trinidad and Tobago. And if we're successful, as with all other cases before the court, the state will then, within their own rights, they will have to determine, you know, where the funds are going to come from. And I know that's sort of the orientation of the question. So for us, the short answer is that the funds will come from the state of Trinidad and Tobago.
Thanks, Dr. Anton. You also have thanks from Kathy Howie. She says, many thanks to Dr. Anton and the team for your efforts. They are so much appreciated. So just to remind you that there is information available on the BACOL website. That is www.bacol.info, www.bacol.info. There's a lot of information there regarding the background to the case and what has happened to date at different junctures of the proceedings. So you can get further information there. Do remember as well that the hearing is coming up on the 29th and 30th of April. We may not necessarily be able to get you a live link to the proceedings on the 29th, but certainly you will be able to follow the proceedings on the 30th. And we encourage you to spread the word and let other people know that the hearing is coming up next week. And if you can, please join, because it will show that you are not just sitting back and waiting for BACOL to represent you. You yourself are interested in the outcome of the proceedings. Alfred would like to know if the case includes benefits for former workers of British American, or is it just for the policyholders?
This case is only about the policyholders. We know that we've been approached by a number of the employees of BACOL, former employees of BACOL, but this is only for the policyholders. There are other approaches that have been made to us now that we believe there is more information available to allow us to support other small cases, but the answer to the question is no, only policyholders at this stage. And before you wrap up, I just wanted, before people disappeared, this is policyholders and the press and colleagues, to say that it would be remiss of me, even before we close, not to remind you that but for a colleague being called home to his heavenly father, Gerald Thompson, we would not be here. Mr. Thompson passed away in 2021, just before we went to the court. And he was a distinguished international trade expert from Trinidad and Tobago, perhaps the best in our community. And he worked on this matter with me in this office with us, literally for nearly 10 years on this matter. We did the comprehensive brief to convince lawyers that it made sense to invest in this process. And unfortunately, he is not here to see this matter being heard by the court. But on every occasion that we meet, I feel compelled to remind colleagues that but for his investment in this and us, we would not have reached this far either. And so, again, I'm just so gracious and so grateful to all of you, including Ms. Menz, who was really taking the time at short notice to drop everything and to be here with us on this media briefing today. And I continue to be grateful for Hiruna Media, and I continue to be grateful for all of you.
The proceedings today will be posted on the BACOL website as soon as possible. And for those of you who have received the stakeholders update, you will find the link to the hearing, that is the hearing on the 30th, in that update. And if you don't have one of those updates, please give us your contact details so that we can send you that update with the link. And if you already have your update and you're having problems accessing the link, you can go directly to the CCJ's website under the tab Judgments and Proceedings, and you will find the link there. So the link is available from the CCJ's website, and it is also available in the updates that we have posted at Hiruna Media. I'd like you to give yourselves, all of you, a round of applause. As the panelists have said, this is a historic action. It is the first class action in the Caribbean, and it is an action brought by private citizens, not by corporations, not by governments, not by businesses, except in their own capacity as policyholders, but by you, ordinary folk who walk the street. So congratulations to all of you, and let us keep our fingers crossed. Those of you who are praying people, let us continue to pray for a very favorable outcome.